good morning. This is Saida Yusabal and our case is Intellectual Property Association of the Philippines versus Paquito Ochoa, GR number 204605 on the year 2016, 17, and 19. So let me read the facts of this case. So in this special action for certiorari and prohibition, the Intellectual Property Association of the Philippines seeks to declare the accession of the Philippines to the protocol relating to the Madrid Agreement concerning the international registration of marks or Madrid Protocol unconstitutional on the ground of lack of concurrence by the Senate, and in alternative to declare the implementation thereof as unconstitutional because it conflicts with the Republic Act number 8293 or otherwise known as the Intellectual Property Code of the Philippines. So what does that mean? The Intellectual Property Association of the Philippines, or the IPAP, would want to challenge the President of the Philippines to declare the acquisition or the accession of the Philippines to the protocol relating to the Madrid Agreement unconstitutional because of the lack of concurrence or appearance of the Senate during the process of that agreement. Therefore, to further understand what Madrid Agreement is, Madrid Agreement is an international registration of marks, provides a one-stop solution for registering and managing marks worldwide. It also allows trademark owners to file one application in one language and to pay set of fees to protect marks in up to 120 countries. However, the Philippines have been part of this agreement and they have been registered on the year 2012. Here's the issue of this case. Whether or not the IPAP has locus standi to challenge the President's ratification of that said agreement, locus standi meaning the right to appearance of the executive in a court of justice to answer a question which is the IPAP would want to challenge to the President, or whether or not the President's ratification of the Madrid Protocol is valid and constitutional, or whether or not the Madrid Protocol is in conflict with the IP Code.
So hello everyone, I am now discussing the ruling of the court for our presentation. So here, the court dismisses the petitions for certiorari and prohibitions for lack of merit and orders the petitioner to pay the cost of suit. Why? Because the petitioner, which is the IPAP, misapprehends the procedure for examinator under Madrid Protocol. The difficulty which IPAP illustrates is minimal. According to the court, Philippines' accession to the Madrid Protocol is constitutional. The right of executive to enter into binding agreements does not need subsequent congressional approval because it has been confirmed by long usage. From the earliest history, Philippines has been entered into executive agreements covering such subjects such as commercial relations and most favored nation rights, and etc., in which this validity has never been seriously questioned by the court. Under the Act of Congress on March 3, 1881, agreements with respect to the registrations of trademark have been concluded in executive with various countries, in which the court had also made the IPAP to compensate the cost of the suit. Suit means litigations or demanda in Tagalog, for the reason that suit are brought by the concerned citizens, taxpayers, as well as the voters, who are actually sue in public interest, not by the parties who are personally injured by the operations of a law or any other government act. Lastly, accessions of the Philippines is constitutional because the Madrid Protocol does not amend or modify the Intellectual Property Code of the Philippines on the acquisition of trademark rights, considering that the applications under Madrid Protocol are still examined according to the relevant national law.